Okay, welcome everybody to this Glasgow Centre for International Law and Security webinar. We're continuing our series of regular Wednesday talks on topical issues. We've had talks in recent weeks on European Court of Human Rights litigation, on conflicts with Dr. Andrea Varga. 2 weeks ago, we spoke about strategic human rights litigation with Professor Helen Duffy. Today, we're moving from the courts, away from the courts, you might say, to the Security Council, another major player and actor in international law, and we'll discuss aspects of international law that resurface in the Security Council. And we'll be discussing those with Eran Sthoeger. Eran is a consultant and litigator in international law based in New York, close to the Security Council. He has impressive academic credentials, including as adjunct professor teaching at Hofstra University and at Seton Hall University. But what sets him apart from our speakers of the past few seminars is his really sort of super impressive practical experience. He's a litigator, counsel, and advocate in many international proceedings before many, indeed, the most prominent international courts, from the International Court of Justice to the International Tribunal for the Law of the Sea, and many other international courts and tribunals. So he's a real hands-on litigator in international law, that field of law that is often said to be not properly a litigation field. Well, it is, and Eran's career is proof that this is so. Before becoming almost like a full-time litigator, Eran spent 10 years as a policy analyst for Security Council report, one of the more remarkable initiatives and indispensable to anyone doing in-depth work on the Security Council. This is particularly important because today Eran will speak about the topic that kept him busy for a decade, the Security Council. He will not speak about the Security Council as an enforcement agent of international law or about Chapter 7 primarily, but his topic is the Security Council as a forum for international dispute settlement and legal discourse. Eran, we're delighted to host you for this webinar. Before I give the floor to you, let me make 3 comments of a housekeeping nature. First of all, as for the sequencing, we'll do this in 3 parts. First, Eran will speak. And for those of you who are excited, I can promise even a little video sequence as part of that. Then Eran and I will continue his presentation in the form of a conversation for around 15, 20 minutes, depending on how long I put my questions. And then we'll open up at 1:45 for British time for questions and answers. That's the program. I should say that we're recording this event. You were informed about this, so we presume this is fine with you. If not, then perhaps turn off your camera now or even drop out, but we prefer you to stay online and be fine with this. Then, final remark for the questions and answers. I mean, as I said, this will be the third and in some ways the most important part of this event. We would encourage you to participate in that and make use of this opportunity because Eran is really sort of knowledgeable and keen to hear your questions as I am. The questions and answers will be moderated by Pia Husch, one of our PhD students, and I'm grateful for that. We can do this spontaneously, just raise your Zoom hand and then you'll be called upon. But in order to give you priority access in the Q&A session, there's no harm in sending chat messages while Eran speaks or while Eran and I discuss and indicate to Pia or Alex or even to the whole world or the whole chat community here that you have a question and then we'll call upon you. That's the plan, and this is the end of my housekeeping remarks. Perhaps one final point. We'd encourage you to keep your cameras on. You don't feel required. We won't enforce this. It's a bit like international law. There's a soft power to this encouragement, not much more than that. But it's nice, if only for the speakers who then don't speak into a world of white or black tiles, but see actual people suggesting that they're speaking to an actual audience. So much for now for introducing this seminar. Eran, we're delighted to have you. I'm very curious to see what you'll have to tell us about the Security Council, the topic on which you know so much. You have the floor. Many thanks.
Thank you, Christian. Thanks for having me today. And thank you, Alex and Pia, for organizing, and anyone else that may have helped organize, which I'm not aware of. So I really appreciate it. And I thank you for the opportunity to speak about a topic that, as Christian mentioned, I covered for many years and continue to cover as a bystander. And hopefully I am knowledgeable about it because I spend a lot of time, and otherwise it would be a big shame if I don't know much about the Security Council. Just one disclaimer, I don't represent any government, but these views are my own, and not everybody necessarily agrees with each view I'll express. And I encourage those of you that do or don't to ask questions and challenge these positions. With that said, let's talk about the UN Security Council. I'll just give a few introductory remarks and then we'll have a video. Unfortunately, it's not a cat video, it's a diplomats exchanging views. And then I'll just say a couple more things and hand it back to Christian. So the council, as you probably know, it's a body comprised of 5 permanent members, 10 elected members, and it's charged with the primary responsibility of the maintenance of international peace and security. According to the charter, when the council acts in this capacity, it does so on behalf of the wider membership. To carry out its responsibility, the council can make recommendations to states about how to resolve their disputes peacefully. It could also impose binding measures. When it finds that there's been a threat to international peace and security, a breach of the peace, or an act of aggression, it can resort to some of its extraordinary powers, both binding measures short of the use of force, such as sanctions, or when necessary, even authorize the use of force. So the council has extensive powers, albeit within the limited field of international peace and security. And those powers receive much attention, and rightfully so. They're very unique and obviously very significant. But as Christian already indicated, that's not what I wanted to talk about today. What I do want to talk about is how, when the council goes about its work, it also does other things which have legal ramifications. And I wanted to focus on a couple of those today. So the first is the council's function as a forum for the settlement of legal disputes. It's not a court, but it does settle legal disputes. In order to put out fires, so to speak, at times the council makes legal determinations. Sometimes people refer to these as quasi-judicial determinations. So in this way, one can say that the council, in essence, is performing the functions of a dispute settlement mechanism. For example, when the US and the UK demanded the extradition of the 2 Libyans suspected in downing the Lockerbie, the plane over Lockerbie, and Libya insisted that it wanted to investigate the matters itself under the 1976 Montreal Convention, the council settled that legal dispute by deciding that Libya must extradite the individuals, and it imposed sanctions in order to force Libya to comply with that decision. Or in another example, at the conclusion of the first Gulf War in 1991, the council established a UN compensation commission, which has since then awarded more than $50 billion in compensation for death, injury, damage to property, environmental damage to a variety of actors, states, IOs, companies, individuals, and all of this from Iraqi oil profits. So again, this is the council settling a dispute with binding force and a very hefty price tag imposed on Iraq. So that's the first issue. Now to the second one I'd like to explore further with you today. So when an event requires the council's attention, for example, when one state uses force against the other, notwithstanding the fact that the council is a political body, assessing the legality of the act in question may also be relevant. And on occasion, discussions in the council surrounding a current event can touch upon or reflect the views of states on the rules of international law more generally. So the second aspect of the council I wanted to discuss is the council when it serves as a forum for states to exchange views or even argue about substantive issues of international law. Or in other words, the council is a forum for legal discourse. That legal discourse can reflect state practice and opinio juris of the participants in the discussion. Some would argue that it reflects the practice of the UN as an organization in itself, and it may even progressively develop the law. But not to talk in the abstract, I thought it might be useful for the audience to get a flavor of what such discussion with legal argumentation actually looks like for those of you that don't watch council meetings regularly. So indeed, I brought a video, and this is a short clip from April 2018, just to give you a bit of the backdrop to what we're going to see. So the council here is convened on a Saturday morning. And of course, if the ambassadors find themselves in the council chamber on a Saturday morning, you know something serious is happening. And indeed, this was the day following the day where France, the UK, the US attacked targeted Syrian facilities they claimed were related to its chemical weapons program. So much of the discussion turned on the legality of those attacks. And so let's take a look at some of the highlights from that discussion. So Alex, if you can please put on the video. Thank you.
Russia called for this urgent meeting of the Security Council to discuss the aggressive actions of the United States and their allies against Syria. This is the 5th meeting on this topic just this week. The president of the Russian Federation, Putin, made a special statement today, and I will quote him. On the 14th of April, the United States, supported by its ally, launched an airstrike against military and civilian targets of the Syrian Arab Republic. Without a mandate from the United Nations Security Council, and in violations of UN Charter and norms and principles of international law, an aggression against a sovereign state was carried out, which is
responsible for its atrocities against humanity. We can all see that a Russian disinformation campaign is in full force this morning. But Russia's desperate attempts at deflection cannot change the facts. A large body of information indicates that the Syrian regime used chemical weapons in Douma on April 7th. There is clear information demonstrating Assad's culpability. The pictures of dead children were not fake news. They were the result of the Syrian regime's barbaric inhumanity. And they were the result of the regime and Russia's failure to live up to their international commitments to remove all chemical weapons from Syria. The United States, France, and the United Kingdom acted after careful evaluation of these facts. The targets we selected were at the heart of the Syrian regime's illegal chemical weapons program. The strikes were carefully planned to minimize civilian casualties. The responses were justified, legitimate, and proportionate.
The Syrian regime has been killing its own people for 7 years. Its use of chemical weapons, which has exacerbated the human suffering, is a serious crime of international concern as a breach of the customary international law prohibition on the use of chemical weapons, and this amounts to a war crime and a crime against humanity. Any state is permitted under international law on an exceptional basis to take measures in order to alleviate overwhelming humanitarian suffering. The legal basis for the use of force for the United Kingdom is humanitarian intervention. Mr. President, I would invite those like the Russian ambassador who speak about the Charter to consider the following. It is hard to believe that it is in line with the principles and purposes of the Charter to use or condone the use of chemical weapons. And in the United Kingdom's view, it cannot be illegal to use force to prevent the killing of such numbers of innocent people. I will take no lessons, Mr. President, in international law from Russia.
But even if this Council fails to act, it should be clear to the world that the use of chemical weapons is never permissible. Mr. President, against the background of past horrors and the unabated risk of recurrence, the response by France, the United Kingdom, and the United States is understandable. The response was measured in targeting targeting a limited number of military facilities that were used by the Syrian regime in its illegal chemical weapons arsenal. The action taken by these three countries made clear that the use of chemical weapons is unacceptable.
All right, thank you, Alex, for that. So as you heard and saw, the council was discussing, was engulfed in discourse. I mean, some of it, of course, political, but also legal discourse. Some members took clear positions like the UK and Russia, UK saying there is a right to humanitarian intervention and Russia saying this was an act of aggression. The US took a more legally ambiguous position. So it spoke about things like necessity and so on, but ultimately it didn't justify the use of force as such in legal terms. And some were trying to avoid legality altogether, like the Netherlands talking about an understandable attack, which is not exactly a legal standard. But at the end of the meeting, Russia tabled a resolution condemning the attacks as an act of aggression. The draft resolution received 3 votes in favor, 8 against, and 4 abstentions, so it failed to pass. But this is just one example where the Security Council serves as a forum for legal discourse and potential subsequent action. Naturally, the Council does this on a case-by-case basis, but the legal effects of this discourse, in my view, can go beyond the immediate issue and have wider legal ramifications. So those are the 2 issues I would like to explore with you today. And with that, I think I'll give it back to Christian and we'll take it from there. Thank you.
Well, thanks, Eran, for setting up the debate and already sort of hinting at some of the key issues we're going to discuss. Let's discuss and perhaps let's disagree. I mean, you want us to disagree with you. Let's see whether we get to that point. As I mentioned, Eran and I will sort of have a bit of a bilateral chat for the audience for 15, 20 minutes or so. Do listen in, note your agreement and disagreement with Eran or with me, and do jump in. You'll have ample time after when we open up for Q&A. Now, Eran, let's jump right in. I mean, I think this has been instructive, and I think let me focus first of all perhaps on the discourse part. I mean, you had dispute settlement and legal discourse. Let's start with the second point, and I think the video is helpful in showing that the Security Council does discuss legal issues. Now, I'd be curious to hear your view on why it matters. I mean, everybody discusses the use of force. When Britain joins an Iraq war, you discuss it with taxi drivers and in classrooms. States discuss it. The General Assembly discusses, the European Parliament discusses, national parliaments discuss it. What makes Security Council discussions or debates particularly relevant legal discourses? And by that, I don't mean the resolution, which is something that you and I cannot pass or cannot meaningfully pass, and only the Security Council can pass. But look, we're discussing the use of force. Why is the Security Council's discourse more relevant? And what sets it apart from all these other ubiquitous discussions about the use of force?
Well, thank you, Christian, for that. Indeed, we're discussing the use of force, but dare I say we're not as important as some of the actors in the Security Council. Also, I would say it's not that I want people to disagree with me, but I welcome the discussion, of course. So yes, a lot of different forums discuss issues of use of force and other legal issues in the UN itself, whether it's a General Assembly, and those are very important discussions. Other political bodies, experts like in the ILC and so on, and of course courts discuss these legal issues. They're all important forums. I think where the Council is, I wouldn't say most important, but very important, is particularly when it comes to issues of use of force. Issues that are in the heart of the primary responsibility of the Security Council under the UN system. It's in that area of the law, or in particular, where I think the Council is most relevant, because I don't think there are a lot of forums where states openly and publicly exchange their views, including legal views, in a group with many states together about these issues when it comes, and they do so with respect to a particular incident. So it's very practical. It's not a theoretical debate about the law. It's something happens, something requires the international community's attention. It requires the Security Council's attention. And the Security Council has to, or should at least, consider the various aspects, including the legal aspects. And so it's a practical way of addressing the law. And in terms of the sources, for example, we're talking about state practice and expressed opinio juris, which, with all due respect to some other bodies, this is the heart of what informs international law. So I think when the Council is discussing these types of issues, I think that's where it's most relevant and deserves our focus as a key area where the Council can develop and reflect the view of international law on particular issues.
Okay, I mean, thanks. That's helpful. And I think it also points towards ways of, if you want, operationalizing the statements that we've just heard, opinio juris, state practice, perhaps subsequent practice. Two quick follow-ups. I mean, one is there anything more to it? Because you might say if a state says something in the General Assembly on use of force or anything else, that's also state practice, that might also reflect an opinio juris, and you could say that the sources doctrine has primarily been developed with respect to General Assembly, let's say, expressions of views, not necessarily the Security Council. So is there anything more? Perhaps you seem to be hinting at it because of, let's say, the particular subject matter expertise or the Security Council's main responsibility in terms of Article 24 of the Charter for International Peace and Security. Is there anything added, do you think, in terms of the sources beyond statements counting potentially as state practice or subsequent practice? And perhaps as an annex to that, is this not a bit dangerous? Because, I mean, is it desirable for international law to privilege the voice of 15 states that happen to be sitting on that privileged body, or let alone the 5 that sit there all the time?
Oh, thanks, Christian. Perhaps those two questions, I think, are interrelated in a way. Yeah, the Council, it has its 5 permanent members, and the other 10 are rotated every year. 5 of them enter, 5 depart for terms of 2 years. And in that sense, I don't think the issue is with representatives of the elected members, but of course, some would argue that it giving the Council added weight in a particular field gives too much weight to the views of some Council members, the permanent members. But we have to remember a few things. First, whether we like it or not, the Council, the Charter says that the Council, when it acts in its function as for the primary responsibility of the maintenance of international peace and security, it does so representing the wider membership. It does so on behalf of the wider membership. So that's how it was structured. And we can talk about whether the setup of having 5 permanent members makes sense or not, or whether it's still justified, maybe it's obsolete. There are varying views about that. But the Charter gives the Council the primary responsibility when it comes to peace and security. So that doesn't mean the GA doesn't have anything to say, but that's relevant. But it does attach, in my mind, more authoritative value to what the Council discusses. And perhaps more importantly, and this goes to your first question, the added value here is mostly because not only does the Council discuss, it then adopts measures perhaps based on these legal views or political views and also their legal views about the use of force. So yes, some of these legal views are not binding, but at the same time, they can be binding. And they do have purpose that goes beyond what the statement itself. And let me just give you a few examples as to what I mean by the fact that they go beyond the issue itself or beyond the statement. They have a much wider ramification. So yes, the council can make legal determinations, and of course those determinations are not necessarily binding. Sometimes they could be binding, and sometimes they're not binding. But they both serve a purpose, and they both have influence. But let me show you what I mean. So when the council makes a legal determination, sometimes that determination itself is not legally binding. So for example, when it determines that a state has committed an armed attack, and then the other state has a right of self-defense, that determination itself is not legally binding. It's the view of the council as a matter of law. So for example, when the council determined in 1990 that Iraq committed an armed attack against Kuwait while invading Kuwait, and therefore Kuwait has the right of self-defense. That's the view of the 15 members on the events, but that determination is not legally binding. So for example, if the ICJ were to find that it was the other way around, that's perfectly fine for the ICJ. It's not a binding legal determination. But where does the particular force and authority of the council come in, and where does it make the council more relevant? 4 days later, after that initial determination, the council imposed sanctions on Iraq based on its previous determination that Iraq committed an armed attack against Kuwait. Now, the sanctions are binding on the wider membership, but even though the legal determination behind the sanctions are not binding. But it shows you how the legal determination goes beyond just expressing views of state practice and opinio juris. Another and perhaps more controversial example, because some would argue that the council was acting beyond its scope, but think about the council's referrals to the ICC. So in Darfur and Libya, the council referred the situations to the ICC under Chapter 7. And in those referrals, the council decided that Sudan and Libya shall cooperate with the court. And it also decided to exclude certain nationals from the jurisdiction of the court in a very controversial move. Now, I would say that when the council does that, that decision of exclusion is binding on the members because obligations under the charter prevail. So if you're a party to the ICC statute and you're also a UN member, even though the ICC statute might have imposed certain obligations, your obligations under the charter prevail. So if the court were to issue an arrest warrant for an individual that's been excluded by the council from its jurisdiction, in my view at least, as a UN member, you must comply with the council Chapter 7 resolution and not the arrest warrant of the court. Now I know, and I see Christian smile, that not everybody would agree with that assessment. However, this goes to the point of who is bound by council decisions as well. Even in that situation, I would say that since council decisions are binding on the membership and not as such on international organizations, the ICC, for example, is not bound by the council's decision. So the ICC, if it did issue that arrest warrant, was perfectly within its rights because it's not bound by the decision. However, will that arrest warrant have practical effect depends on the obligations of the member states. So these are examples, in my view, where, yes, the legal discourse is discourse that may be had in various places. I do think it's most important when it's had in the Security Council because the council is focused on these issues and the determination by the council, in my view, is authoritative, much like you would say perhaps of an ICJ advisory opinion. But perhaps the key issue here is that the decisions sometimes lead to binding measures, and sometimes the decisions themselves are legally binding. So that's where I see the council as a key actor and most relevant.
Okay, I think that's helpful, and it also shows that the two parts of your talk in some ways are intertwined, because it seems to be that the relevance as a forum for discourse comes from the dispute settlement function and the possibility to settle to impose binding decisions. And I'll come back to that hopefully, or the questions and answers will come back to that. But let me stick with the discourse aspect just one more round of questions, and that goes to something you said at the beginning of your response. Let's say the legitimacy concern, whether it's proper that a limited number of states ought to be having that possibility to express a view which you consider to be particularly relevant for the interpretation of the law. Now, in some ways, the Security Council occasionally steps out of its limited formation and embraces the wider world. And it holds ARIA formula meetings, with apologies for Spanish Latin American native speakers who can tell me how this is properly pronounced. And it just so happens that to show how topical your talk is, that the Security Council just had one of such meetings 2 weeks ago. So when it invited states to comment on self-defense, another issue on which there's hardly any disagreement in the legal discourse, and in particular the scope of self-defense in response to non-state actors. Would you think, because you emphasize, let's say, the hands-on, the practicality, you emphasize the functions of the Security Council and the powers under the Charter as factors that make these discussions to be relevant, would you say the same relevance should be given to these wider meetings, which are abstract and purposefully decoupled from particular instances where no sanctions are imposed later, but still there's a wide array of views and opinions that are being voiced? So is this equally relevant, or is this more like a General Assembly chat, or where do these expressions of views rank in your assessment?
All right, thanks, Christian. Well, first of all, it's important you mention these types of meetings, because they do go to the point that, yes, we're talking about a forum of 15 members, but others participate. So in many meetings of the council that discuss legal issues, other states participate. There are rules of procedure that allow them, the provisional rules of procedure that allow them to participate and voice their views as they would in other forums. And as you just mentioned, the ARIA Formula Forum, and there are other unofficial forums. This was an ARIA Formula for council members, but it was also with the participation of the wider membership. It was organized for these members also to express their views. So that's just to point out that participation is limited, but not always, and there's room for wider participation. But that said, I do think that the council, when you think about the council as opposed to other bodies, the ICJ, for example, the GA, these bodies, the court has general competence over matters of international law and subject matter wise. It discusses a variety of issues. So on occasion, it has a case that has some use of force issues in it. And we know they had these cases in the past, but that is depending on the case that comes before it. The GA also discusses matters of international peace and security, of course, and can make recommendations. But it's only the Security Council that, to the extent that these issues come up, discusses them on a regular basis, and is the primary forum for these things. So I think the council has a special place. I read in an article that Kless and Nussberger say somewhere that the most important forum for states to debate the jus contra bellum outside judicial proceedings is the council. Now, I put to you that the council may not always be equally important to the development of the law of courts, but it could be as equally important, and perhaps even more important in the development of the law, and in some instances. To me, that makes total sense. A, because as we already mentioned, it's a forum for state practice and opinio juris in terms of sources of law, but also because it's where use of force issues are regularly discussed. So to give that more meat, you mentioned self-defense against non-state actors. Now, we all know the ICJ has said that that right exists only in response to an armed attack by a state, right? It said that at least on a couple of occasions. Now, the Council has also considered this issue many times. After 9/11, in relation to the actions of Al-Qaeda, a non-state actor, it recognized the inherent right of individual and collective self-defense in accordance with the Charter. And as global terrorist threats became more prominent, practice of states acting in self-defense against non-state actors increased as well. So fast forward to 2014, Iraq notified the Council that it's asking the US to lead a coalition against ISIL, operating in its own territory, but also against its strongholds in Syria in order to exercise Iraq's right of self-defense against a non-state actor. Then the US and other Council members notified the Council that they were going to assert Iraq's right of self-defense in Syrian territory. And of course, all of this was done without Syrian consent. In fact, against Syrian protest. After the Paris terrorist attacks in 2015, the Council went further. It adopted Resolution 2249, where in a very admittedly cumbersome and grammatically difficult and not entirely straightforward way, it said that it called on member states that have the capacity to do so to take all necessary measures in compliance with international law on the territory under the control of ISIL in Syria and Iraq. And we know that all necessary measures is code for use of force. And then what happened is that France and other NATO members explicitly claimed the right of self-defense against ISIL on their behalf, on behalf of others in Syria. So here, I would argue, and then Christian, you just mentioned the fact that just last month, we had again a debate on this issue and others with respect to non-state actors and the right of self-defense under Article 51 and the ARIA formula meeting format. In that debate, in that discussion, the meeting, the views, various views were expressed on this issue in terms of the substance. But one thing I thought that came out of that was this underlying assumption or fear of all the wider membership, or not all, but many of the wider membership, that discussions in the Council, as well as Council reaction or inaction to claims of self-defense against non-state actors, have legal and practical consequences. I think that was the underlying assumption of the discussion, that what's discussed and done or not done in the Council makes a big difference. So I would argue that at least on this issue of, and again, I know it's not the view of everybody, but on this issue of self-defense against non-state actors, the Council has been more influential than the court. Or at the very least, I would argue it reflects more accurately the attitude of many states in practice. So here's a good example, and it's not always the case, where the Council is more relevant, legally speaking, than the views of the ICJ. So I'll leave it at that.
Okay, well, that's I'd love to take you up on that challenge, and I mean either the sort of the comparative relevance of the two bodies, or indeed the question of whether self-defense against non-state actors is permitted. I fear if we are having that discussion, Eran, we won't stop before 9 p.m. And I see Michael Wood and Federica Padeu sort of trying to sort of. I think they have firm views on this as well, at least from their writing. So I'll be curious to see whether they rise to the challenge. I won't rise to the challenge of discussing self-defense against non-state actors now, because I want to ask one more question, which at least surveys the other aspect of your presentation, or of the title of your presentation, which I've somewhat neglected now, and that's the dispute settlement dimension. And I think you've made the key point that the Council does that quite regularly, perhaps in a way that is not always fully appreciated by students or teachers of international law. And I think that's vital. and that, of course, when it imposes sanctions, its involvement in disputes has a particular quality. Now, I'd be curious to see whether you feel or whether you think there are any limits to it. You've mentioned the UNCC, which to reiterate is the particular claims commission that the Council set up in the aftermath of the Second Gulf War in the early 1990s. The Council has also set up criminal tribunals, and I recall, playing the age card here, that at the time this was at least controversial, because the Council has also settled boundary disputes. And so I think I'm putting the question in relatively general terms. Granted that this is happening, but should this be happening? And should there be limits to what the Council can do as a dispute settler? Because as you've said frequently throughout, it's not a court, it's a political organ. Should that political organ be setting up courts? Should it be settling boundary disputes? And should it be able to do, through creating organs, create something that it itself perhaps could not do as a political organ? That would be my attempt in a relatively broad and meandering question to survey the second topic of the title of your presentation.
Thank you, Christian. Of course, all easy questions to answer. And at least I'm thankful that we're not going to discuss self-defense against non-state actors. Well, I mean, it's a good question, but I would frame the question a bit differently. I think there's a difference between should and can, right? Should the council set up the criminal tribunals in the 90s? Should the council set up a compensation commission? Should it enforce a boundary demarcation or a delimitation, depends how you look at it, between Iraq and Kuwait? Should it do all of these things? I think is a matter of policy. I think it's a matter of opinion. And I think there are good reasons to argue for or against a certain action. I think as a lawyer, for me, the question is, can it do these things? And I think in that sense, and again, I know not everyone agrees, but I think the council can do many, many things. And its limits or the boundaries are very scarce. So, I mean, I think we can all agree that the council cannot violate jus cogens norms, that it's subject to the purposes and principles of the charter, whatever that may mean. But ultimately, what the power given to the council in chapter 5, 6, 7, 8 is to do what's necessary for the maintenance of international peace and security. Now, what's necessary has changed over time in terms of our understanding. What constitutes a threat to the peace, we all know, has expanded significantly. We know that in 1945, the world was focused on interstate disputes rather than intrastate disputes, rather than disputes with non-state actors, and so on. Not, you know, international terrorism was not undermined, and so on. So all of that has changed. In my view, what the council legally can do is everything that's necessary to international peace and security. So if what's necessary is to establish the criminal tribunal for the former Yugoslavia, you know, and that was not, that was controversial at the time, at least for some lawyers, I think that's within the council's purview. The ICTY unsurprisingly agreed that it was a legal body, and founded and was not ultra vires. Can the council demarcate boundary, or it didn't demarcate the boundary, but it set up a mechanism and forced Iraq to accept it? Can it do that? Since it found that the boundary issue was one of the factors among many that caused the dispute between Iraq and Kuwait, and it found it necessary, I would say yes. If it found it necessary to restore peace and security, to obligate Iraq to pay billions of dollars in compensation, yes, that's what's in its purview, if it's related to international peace and security. I would even argue, I mean, we all know that the council under chapter 6 can recommend parties to go to the ICJ. It's done so only once. But I would even argue that if the Council thought it necessary for international peace and security, it could act under Chapter 7 and force parties to go to the International Court of Justice. I would say even that isn't within the Council's purview. Of course, I don't see it politically feasible that it would actually do something like this. But again, I think the powers are not unlimited, but they're very wide. What constitutes a threat to peace and security is a very, today is considered a very wide term. A pandemic, a health crisis could constitute a threat to international peace and security. And so I would say that there are very limited limits on what the Council can do legally. Now, whether it should do those things, going back to my first point, is a matter of policy, and it's a matter of opinion. And hopefully the Council will only do things which serve international peace and security in our view.
Excellent, many thanks. So I think that hope is widely shared. A nearly limitless guardian is hopefully going to exercise his or her powers wisely. Let's see whether we're left with just hope and use Kogan's, or whether there's other limits. Okay, look, lots of things that I'd love you to sort of pursue. I'd love to pursue, but there's a time for everything, and now's the time for Q&A. So I'll hand over to Pia shortly, with thanks to her and to Alex Sobirai. Let me just sort of encourage you to sort of put your virtual Zoom hands up if you want to join the discussion. I think Eran has given us a lot of food for discussion, disagreement, or agreement. So I hope we'll have an engaged and interesting discussion. As I hand over, let me just sort of thank Eran again. I think that's been very instructive, and I think speaks to your insight, knowledge of the Council's working. And I think I've certainly learned a lot and could go on for hours discussing it. But I'll withdraw from that now and leave the floor to others, and in particular now to Pia. Many thanks.
Thank you so much, Eran. Thank you so much, Christian. That was great so far. I hope we can keep up the level of the discussion. Great that you shared so many of your opinions and also controversies here. And I'd like to invite everyone to use this opportunity to ask their questions, or perhaps share their comments where you maybe agree or disagree so far. So please raise your virtual hand or use the chat function to submit your questions. And I see we already have a question from Mark, so please go ahead and kick off the Q&A.
Thank you very much, and thank you for the presentation and for the organizers to hold this event. My name is Mark Lamberg. I'm a professor of international law at Stockholm University, and we are running a project on interpretation of Security Council resolutions and the status of explanation of votes. So the topic of today is very relevant for our project. And first a comment, and then I'll follow up with a question. So my idea at the moment is that what happens in the Security Council and what states say, I mean, that's part of the discourse. It can either be used as a means of interpreting Security Council resolutions. That's one function. But it can also contribute to customary international law, and that's what I understand that you're also arguing, Eran. So that's good. My question is the following. I mean, when states do something or say something in the Security Council, is that only of relevance for some kind of UN Security Council practice in a narrow sense? Or can it also influence customary international law in general? That's one concern that I have. So if you could comment on
that. Thank you, Mark, and I'm glad we agree on a few things. I think, what is said, I'll start with what you asked, and then I'll comment about your comment. What the Council says, or what's discussed in the Council, I think has wider ramifications. We mentioned the ICTY. In the 90s, the Council expressed its view twice in the context of the internal conflict in Somalia, that those that violate IHL in that conflict can and shall be held accountable, criminally accountable, individually accountable for their actions. So what the council is saying here is that there is individual liability or accountability in non-international armed conflicts in that context. And this was not a given when this was said in the early 90s. And indeed, it was a question the ICTY faced. And the ICTY quoted these council resolutions as part of its proof that individual accountability exists in non-international armed conflicts. So I think that's a good example of where the council developed the law, or was part of the development of the law. It didn't do so on its own. Now, whether that's because you give particular value to the view of the council as a body responsible for international peace and security, or the 15 views expressed in that resolution, so their opinio juris, I mean, you can, I think it might be both, but in any event, it affects the development of the law. Now, of course, there is this wider issue which Mark raised, and that's, you know, what does it mean when a council member does or says something in the council chamber? What do votes mean, right? When a council member votes on a certain resolution for or against, what does that resolution mean? Is it, does it express any particular legal view? Is it of legal value beyond perhaps the binding decision it gives? And I would say, as a rule of thumb, and this is, I think, very relevant to what Mark raised in terms of the legal importance of council decisions. As a rule of thumb, I would say that council decisions, resolutions, statements are reflective of political positions. They're not reflective of legal positions. But it wouldn't be very interesting, and we know international law is very interesting, without exceptions to the rule. And there could be various exceptions of when I do think decisions reflect council legal positions or members' legal positions. So one, I think, obvious example is when the text itself has legal language, it adopts a legal statement. So if you think about something like the 1970 Declaration on Friendly Relations in the GA, which has talks to the existence of certain legal rights, obviously, if you vote for that, you accept the existence of those rights. In the council, for example, when it says, as it's said several times, recently in Resolution 2334, that Israeli settlements in the occupied Palestinian territories are illegal, obviously, if you voted for that, that reflects your legal position, because it's a legal statement which you say yes to, or no to, obviously. The second, I'll mention two other possibilities in my view, and that's when a statement is inherently based on a legal presumption. So there's no legal statement in the text, but there's a legal presumption behind it. So that example of Somalia, I think, is like that, but also what I mentioned about non-state actors. So Resolution 2249. If the council is saying that there's a right of self-defense against ISIL, it can't say that unless it presumes there's a right of self-defense against non-state actors, in my view. So there's a legal presumption underlying a resolution that doesn't necessarily state something legal. And finally, I think, and this goes to the heart of what Mark was asking, you know, there could be a text that on the face of it does not reflect anything legal, but if you take what council members say in the buildup to the vote, to the deliberations, or in their explanation of vote, it gives their vote legal ramifications. So what we saw in the April 2018 discussion, you know, there are various votes on the draft resolution calling it an act of aggression. And the fact that a state voted against doesn't mean it thinks the act was legal. But as you saw, when the UK said the act was legal, then its vote, I think, has legal ramifications because it explained in legal terms why it's voting a certain way. But just to give one other example, which we haven't really mentioned today. So in 1981, Israel bombed the Iraqi nuclear facility in Osirak. And then it argued and made a very legalistic argument before the council that it was acting in anticipatory self-defense. and that the actions were proportionate and necessary, and the danger was imminent. And it quoted Waldock, Schwebel, and Bowett, and others. The council then proceeded to adopt Resolution 487, calling it a clear violation of the charter. But what does that mean in terms of the legal rule itself? So I think here you have to look at the discourse. For Mexico, which voted on that resolution, it explained that its vote was due to the rejection of the concept of anticipatory self-defense. So that I think is of legal value. But others focused on the fact that there was no proof that Iraq had a clandestine nuclear program. So it was a factual argument. And the US, on the other extreme, said that it didn't have any principal problem with the Israeli action, but rather that Israel failed to exhaust other options before the attack. And then the UK, to a lesser extent, spoke about imminence being the issue. So therefore, I think if you take those views and look at the votes, you can find some legal consequences to the vote, but you have to be careful because the same vote of Mexico and the United States in that case has different legal meaning because of why they did what they did. So those, I think, are some examples where there could be legal value to voting in the council. And sorry, I know I've been going on, but I just, particularly because Mark, you're from Stockholm, I think it's very interesting to mention one other incident again, Israel in 1976, after the raid on Entebbe to free the hostages. There are other interesting legal aspects there, but I would just mention something that Sweden said there to remind us that votes as a whole are political. So Sweden said that Israel's acts in Ugandan territory to free the hostages were illegal under international law. But at the same time, it said that it found it impossible to condemn Israel because of the circumstances under which it acted. So there's a clear statement of Sweden saying, this is illegal, but politically, we're not going to call it illegal. We're not going to vote against Israel on this. And it shows you that ultimately, as the default rule is that votes are political, but there are exceptions. So.
Thank you so much for expanding on that and commenting on the comment. Let us continue by a second question. Mohammed, I can see you've raised your hand. Please go ahead.
So thank you very much. Thank you for this interesting event. It's honestly very interesting. I have a question about the role played by the Security Council in settling legal disputes. Do you think this role is similar to the role drawn by the United Nations Charter? And whether this role or whether the Security Council has been very active in areas where we have gaps. So the Security Council has been very active when it comes to the international criminal responsibilities, compensation for victims, but it's not very active when it comes to the interstate legal disputes. So the activity or the activeness of the Security Council, it depends on whether we have gaps or not. Thanks.
Thank you for that, Mohammed. I'll definitely try and be shorter this time than my previous answer. You know, there's a lot of discussion about whether the council is stepping outside of its boundaries. You know, people talk about legislative resolutions, as I mentioned, quasi-judicial decisions and so on, and it's a wider discussion. As I express my view, the council can do all of those things as long as it serves the maintenance of international peace and security. But others would argue that the council has long stepped outside of its boundaries. The other thing I would say that, of course, the council is still a political body, and what it decides to discuss or not discuss is political. Sometimes it decides to ignore things altogether. Sometimes it discusses a situation but ignores some of the legal aspects of it. And it's very active against some states and inactive against others. And that's reflective of the politics in the council as well. So you can't separate these actions from the politics. As I said earlier, what the council should be doing, is a question of policy. And yes, personally, I would be hopeful that they would be more active on criminal responsibility of states, of state actors within states and so on, and more active on settling these disputes between states, which are longstanding. But that's ultimately where the politics come in and at times make it impossible.
Thank you so much. Loren, I see you've raised your hand. Please go ahead.
Hi, Eran. Thank you so much for this very interesting discussion. And some of your ideas are very thought-provoking. I want to come back to this idea of the Security Council as a forum for discourse and just raise two reservations on that and see how you'd respond. One is that, and I think we saw that a little bit in the clip that you showed, that when the council members are sometimes addressing legal issues in connection with what they're discussing, they're not making thorough legal arguments of the type you would make before a court or a tribunal. So to what extent does that limit the usefulness of the forum? And the second is that I think to some extent they're not necessarily consistent. You mentioned that the legal pronouncements they're making are in the context of a specific incident, but those pronouncements can vary incident to incident. So I'd be interested in your response.
Thanks, Loren. And it's good to see you virtually. It's been a while since we've seen each other. So, I mean, you're absolutely right. Council members do not always make clear and coherent arguments in the council. So in that clip we saw, you know, when you take, for example, what Nikki Haley was saying, Ambassador Haley, right? She was talking about proportionality, necessity to an extent. She said the attacks were justified. So she didn't really address the actual use of force. It wasn't, as you said, entirely coherent. And I agree with you that it's more difficult to assess legal value of the discourse than it is when you would have a pleading before a court, before the ICJ on the same issue, where it all has to be about the law. And so I think in that clip, it is representative of both what you said and I said, where, you know, the UK and Russia are very clear about their legal positions. And of course they add politics to that. But other countries are very unclear. And the Netherlands was not the only country that used these terms that are completely not legal. So you're right, it's difficult. And that's why I think that it's a matter of extracting certain elements from these discussions or from the votes and their meaning, rather than just taking them as such as legal positions. And that goes to your second comment, which is true, is that there's inconsistencies. So if you want to be optimistic, you would say that council members are developing their thinking over time, and then perhaps they reverse their thinking after further thought. But no, obviously what the council decides to address and what council members, what position they take is reflective of politics. I would say that that's true for international law in general. And, you know, state practice and opinio juris are formed, you know, in reaction to certain events, and obviously the legal positions taken are, you know, affected by the politics. You know, I mentioned the Israel's bombing of the Iraqi nuclear reactor in '81, which received wide condemnation and was condemned by the council unanimously. And then in 2007, Syria sent a letter to the council saying, Israel just bombed our territory, and everybody knew that Israel was claiming it just bombed a clandestine nuclear reactor, and the council decided not to talk about it at all. So obviously, I mean, does that mean that they now accept a right of anticipatory self-defense? Hardly. It doesn't mean that at all. Or that they condone the attack? Politically, maybe. But so, I mean, you have to look at these things and really then, as I was talking about the voting, you really have to look carefully, and only under certain circumstances can you deduct legal relevance from these arguments. So yes, I agree with you.
Thank you so much. Speaking of things that are not very clear and potentially vague, we have one more question from the audience submitted via the chat, and that relates to the idea of securitization of policy. You already mentioned it a little bit, the idea that everything nowadays can be a security threat or a threat to peace and security as such. And the question from the audience was whether, given that there are no checks and balances, could the UN Security Council in theory not simply expand its reach to policy areas outside the scope of peace and security if it chooses to do so?
Well, thanks for the question, and thanks, Pia. Well, I mean, some would argue the council is already doing that, and there's a very lively discussion among council members about whether the council should be discussing various issues, where you have countries on one hand like Russia and China claiming that some of these discussions, for example, discussions about HIV/AIDS as a threat to international peace and security, or climate change and as a threat to international peace and security, they claim that the council is stepping outside of its boundaries, whereas other countries, mainly Western countries, but others sometimes as well, claiming that these are issues that are very relevant today and can pose security threats, such as, for example, water scarcity can cause wars in some areas and so on. So it's a lively discussion. And from a legal standpoint, it goes to how you interpret what a threat to international peace and security is over time. And that, of course, you should do not only with reference to the charter, but also with reference over time to the practice of the council. Ultimately, that's, I think, reflective of the biggest check on the Security Council is the policy. And we saw that, for example, when the council had to add due process rights to its sanctions on Al-Qaeda related to terrorist threats, which it didn't want to do initially, but it was forced so politically by states to add some element, the Office of the Ombudsperson, to provide some due process rights to people on the Al-Qaeda sanctions list. So it's policy that mostly limits the council. It's the member states that force the council to take what in their view are only actions that it should. I think the policy is the biggest limit rather than the law. As I mentioned earlier, in my view, the council has very wide discretion legally to do things.
Thank you so much. Federica, would you like to go ahead, please?
Thank you. No screaming children this time, which is a bonus. So I won't take the bait on self-defense, but I will raise perhaps another issue that I hope Michael would, given his other expertise in the ILC, might not then jump at me. But so what Lorraine mentioned earlier about the inconsistency of statements in the Security Council kind of diminishes your argument about the importance of the Security Council as a place for legal discourse on use of force. And I know Christian already pushed you on this, and I will push even further, if that's okay. So
that's what I'm here for.
Yeah. So if I understand correctly your argument, you gave sort of two different reasons why legal discourse in the Security Council is more important. One of them was that it's because it debates it frequently, right? Questions of use of force, for example, come up before the Security Council very often. And this is just a question of opportunity. It's an entirely contingent question, right? The other answer instead had to do with the Security Council powers. And the Security Council acts under Article 25, it acts on behalf of the organization and so on. And this is really a question of its competence, so it's an inherent question, it's an imminent question about the importance of the council itself. Now, I find the first argument persuasive to an extent, in that it is more important just because we go there more often to find evidence of practice and opinio juris with respect to questions on the use of force. But I find the second one a bit more difficult because it essentially amounts to saying that it's more important because it is said in the Security Council, right? So it's the forum that makes it important rather than just the fact that it happens there all the time. But then this just kind of shifts the ground a bit, because we then move from what states say in the council with respect to what they do or don't do to the institution. And so I'm not entirely sure that that necessarily helps the importance argument, because ultimately we're just not looking at states anymore. We're now all of a sudden looking at what the Security Council as an international organization agency is doing. So on the first point about importance, that it's because it happens there all the time, I can get it. It's just a question of quantity, and we go there often. But on the second point about the importance because of what the Security Council's role is, and that it acts on behalf of the UN members as a whole, I'm not sure that I'm convinced. I wonder if you can help me along the way.
Well, I don't know that I can help, but I can try and think about it or articulate it perhaps differently and hopefully better. So the first one is a completely pragmatic, practical thing that the discussions happen there all the time. And the second, as you said, goes to what the function of the council is. Now, in my view, that's twofold. One is that the organ has been put front and center in terms of its importance under the charter. So it's the organ primarily responsible for these issues. And so in my view, as an organizational matter, the discussions there have heightened relevance or heightened importance. Now, you can put that completely aside from state practice and opinio juris, right? If the United States is saying the same statement in the GA and the Security Council, in that sense, it's the same statement and it's the same. But I think discussions, in my view, the UN Charter gives prevalence when it comes to peace and security issues to the Council, to the importance of what the Council says and what it does. And so I think there is where I see added value. I mean, some people would talk about, the practice of the organ as having legal relevance under international law in terms of practice, the practice of international organizations. So if you look at that, I would say, yes, the Council is more important from an organizational standpoint. And the other element to that, which perhaps is not a legal argument, but just one to me that's logical, is that if you're discussing issues in two bodies, which are exactly the same, but in one of those bodies, you're going to potentially adopt legally binding decisions based on those discussions. I think then, for me, again, perhaps not legally, but logically, those discussions are more important, as opposed to a statement you would make in the GA when either that nothing will happen, or if you adopt a resolution, it's just a recommendation and it will be ignored. So I think that's where I see the Council as inherently, perhaps for me, more interesting, and that's part of the problem, but as also more important and more relevant. So I hope it helps, and if it doesn't, I'll try better next time.
No, it does. Thank you.
Thank you so much to both of you. One more question from Elliot, please.
Hi there, and Eran, thank you very much for the talk. I had one general reflection, which is that we have discussed the Security Council basically as judge, jury, and executioner, or if I try and put it more accurately, as legislator, adjudicator, and enforcer. And I was wondering, either from a theoretical standpoint or a practical standpoint, have you come across any problems with the Security Council trying to wear all of these multiple hats? Does it ever trip over its own feet that it legislates one way and adjudicates differently or enforces differently? Are there any examples of inconsistencies there?
Well, it's hard for me off the top of my head to think about exactly that type of example. But I would say, and since Michael Wood is here, I know he would agree with this, that, thinking about the Council is legislator, adjudicator, an executor, sort of like in the movie Judge Dredd, if you remember that movie, where Sylvester Stallone and apocalyptic futures, all of those things combined. It's really imposing some of our legal understandings of how domestic systems work on the Security Council or the UN generally, where we kind of say, well, the General Assembly is the legislator and the council should be the executive and so on. And that's just the way our mind thinks because we're used to those types of things. Those types of checks and balances and separation of powers are not existent in the United Nations. The body's functions are what they are in the charter. So in the charter, the Security Council is given this very wide discretion and authority with respect to international peace and security. And in that sense, and again, this is not non-controversial, it's really not bound by these distinction of legislator, adjudicator, executor, and so on. So I think that's us trying to impose what we're comfortable with on the council. And we need to extract ourselves from that because yes, the council has all of these powers, but ultimately they're limited to one field of international law, whether you view that field as wide or narrow. But the council can't discuss other issues where other bodies can discuss them. Now, the council has very unique powers, but it's limited in that sense. So it's not a real executive. It's not like the General Assembly is going to adopt a legislative resolution about climate change and the council will implement it. So it's not really I think the best way to understand the council. That said, and going back to what was already said, the council, just like its members, is inconsistent and it acts in certain ways. It treats some scenarios one way, and it might treat the same factual scenario another, depending on the identity of the parties involved. It's a political body. It reflects the politics of the wider membership, and of course, the politics of the membership itself. So it's, in that sense, it's far from perfect and it's far from objective. The membership set it up that way. At a certain time, whether that still works is a big question, but that's a system we put in place for certain reasons. So I think we need to work with that system and make it the best possible, rather than challenge it based on our preconceived notions.
Mark, would you like to follow up on that? No? Okay, just the comment, thank you. Lorena, is that a second raised hand? Do you have a second question or no, just continues? Do we have any more questions from the audience then? If not, I would like to give the word back to Christian and thank you for the great discussion.
Thanks, Pia. Thanks. And I think what I'll say in concluding is largely sort of an extended word of thanks in well-structured 3 stages. Thanks to Pia and Alex for organizing it, for managing it, for hosting it, and for making sure this all works. IT-savvy people can do this. People like me could never do this. So we're grateful, Alex and Pia, for your support of this webinar series. Thanks to the audience. It's great to see this webinar series taking shape. I think we're all agreed that this is second best at best. It would be much nicer to meet in person, but I think we're making do. And I think I'm glad that this is sort of taking shape. It's great to see Glasgow uptake from PhD students and LLM students. To the Glasgow crowd, don't be afraid. Today was a bit sort of dominated in the Q&A by the heavy hitters, the experts. Don't be afraid. This is primarily for you. Do ask questions. There are no silly questions, and all questions are valuable. But it's great to see you joining. It's great to see familiar faces as part of this webinar series, people repeatedly participating. Friends of Glasgow, Federica, Henry de Waale, Mohamed Janabi, Megan Wong, who runs her own brilliant lecture series now, online lecture series at Essex. So it's great to see you joining this discussion. It's also great to see new faces. I'll mention a few who joined the discussion. Mark Plumberg, Lorraine Sievers, sort of experts on this topic. Michael Wood, it's great to see you here, and all the others that I forgot to mention. So, so it's thanks to the audience in general terms. To all the new faces and all the Glasgow students and staff who are joining, let me say that this will be, as I said, this has been recorded and will be shared. We'll be in touch, so you can rewatch if you want to check what has been said and whether Eran was right or Christian was wrong. or Mark had it right, or Federica's question was the absolute key point. You can all rewatch it in a few days or in a week's time. We'll continue this series in roughly 2 weeks with a seminar that's slightly different in focus. We'll go investment. Everybody has to talk about investment, and so do we. We'll talk about the Cairns versus India award, which has pushed boundaries in terms of litigation about tax measures, one of the mega awards that investment tribunals are now famous and infamous for. And we'll have a panel discussion about that in roughly a fortnight, chaired by my brilliant colleague, Tony Mazal. Watch out for the information, or better still, sign up to our newsletter to get regular updates. Alex has posted into the chat function links to the website, to our Glasgow Centre events pages. If you check that, if you make that your customized page that you wake up with every morning, then you'll never miss any event. So that's my encouragement to you. Finally, Eran, thanks for speaking to us. Thanks for sharing your thoughts. Thanks for providing inside information as well as overall assessment. You've had your share of disagreement as you wanted or expected, but I think overall we all agree that the topic you chose is vital and crucial. It's important to see the Security Council as a dispute settlement forum and as a discursive forum also. We may disagree on the value of some of the statements, we may agree on the limits, whether they're as limited as you say, or whether it's politics versus law or whatever, but I think these are vital topics, and I think we're all grateful, and I think in that respect there is probably consensus or unanimous agreement in the audience. We're all grateful to you for having shared your perspectives and views on this topic. So thanks for joining the discussion. Thanks to all of you. And with that, we're closing today's seminar of the Glasgow Centre for International Law and Security. Many thanks.
Thank you.